After years of inaction and unnecessary damaging inquiries, I welcome some positive reforms to the family law system. The family law amendment bills aim to make the family law system safer for women and children, and they do this by putting children's welfare first. The family law amendment bill does a number of things, but including removing the presumption of equal shared parental responsibility, a damaging and regressive provision that was implemented by the Howard government and which has been widely misconstrued in the community and often weaponised in family law court cases to claim equal time with children, even where that is not in the best interest of the child, such as in cases of domestic and family violence. Repealing this presumption will make the family law system safer for women and children. The Family Law Amendment Bill also expands the definition of family member to better capture First Nations cultural norms and kinship arrangements. We support that. I'm pleased to see a new requirement for independent children's lawyers to actually meet with the child and give them the opportunity to express a view about proposed parenting arrangements. We also welcome the broadened duty of lawyers and judges to act to achieve the best interest of children. The Family Law Amendment Bill also gives the Minister the power to develop accreditation standards for family law report writers, which is long overdue. I've had countless people raise concerns with me, both through Senate inquiry processes and in separate meetings with me over many years now, the varied quality of family law report writers. There's no quality control despite the crucial role that those people play in the court process, and the conclusions that they draw are often unquestioned and very difficult to challenge. We urge the government to move quickly on the accreditation standards for family report writers. Get this done. It will have a huge impact and there's not a moment to lose. The main bill also clarifies the restriction on publishing details of family court matters to ensure that information can be provided to relevant authorities. That's obviously similar to the accompanying Family Law Information Sharing Bill, which introduces a new framework aimed at improving access to information from state and territory family violence and child protection systems during family law proceedings. Now, they're important reforms because they empower the family law courts to procure information related to family violence from state and territory agencies, and they provide for the admission of that information into evidence. This brings me to the issue of perpetrators subpoenaing counselling records of victim survivors as part of family law cases. The exposure draft of the main bill did propose some restrictions to this, but they were deleted from the final bill after feedback from stakeholders on this sensitive and complicated issue. Attempting to weaponise a person's confidential records through the family law court is an obvious abuse of power and privilege. And yet, as evidence to the Senate inquiry into these bills made clear, a blanket ban on access to medical or psychological records is not always helpful, as that information can both identify and conceal evidence that's useful to keeping women safe. It is important that the right balance is struck to protect vulnerable people, to ensure that people who are seeking the mental health support and counselling that they need won't fear that information becoming public or known to a perpetrator and then used against them in family law cases, deterring them from seeking the help they need. And it's important to ensure also that the court has the information it needs to decide what's in the best interest of the child. So I'm pleased that the government is reconsidering the shape and the nature of these amendments and working with stakeholders to strike that balance. And we would like to see the government progress those reforms promptly in a way that both protects survivors but also ensures that the court has the information it needs to make the decisions about the best interests of the child. So we look forward to engaging further on that crucial topic. The women's safety sector and legal advocates have long called for a child safety focus, and these bills at least partially deliver on that. However, fair child safety-focused outcomes can only be achieved with adequate resourcing of the court system. The court system was already set back by the abolition of the Specialist Family Court under the Morrison government. Very few in the legal profession thought that the Federal Circuit and Family Court merger was a good idea. Conservative estimates suggest that at least 60% of family court matters involve family violence, and other estimates have it at 90%. Even those that don't involve violence regularly involve complex parenting or property matters. The loss of specialisation in a court that relies on specialist expertise to navigate complex matters and to ensure that the safety of children, has only made those existing pressures more extreme. Reform should strengthen a system, not lead to the diminution of specialisation. The now amalgamated Federal Circuit and Family Court has taken some steps to recognise and expedite family law matters where violence or child abuse is alleged to be occurring, but there is still the need for specialist judges and court officers to properly deliver justice. Moreover, we hear so many tales of how poorly the court recognises and deals with violence against women and children. We urgently need, and this is not the first time I've said this, nor will it be the last, we urgently need comprehensive family and domestic violence education and trauma-informed training for the judiciary, legal practitioners, independent children's lawyers, family law report writers, the police and all others associated with the court process. Justice delayed is justice denied, so in addition to that trauma training, the court needs more resourcing. Review after review has confirmed that the entire family law framework is overstretched and under-resourced. The government must ensure that legal aid, community legal centres, Aboriginal and Torres Strait Islander legal services, family violence prevention legal services and various peak bodies have adequate and secure funding to provide timely advice and representation to parties. Failure to strengthen that legal assistance sector will simply exacerbate delays and costs that directly impact on the accessibility and quality of justice. Whilst those legislative reforms that we're debating today are welcome, full funding for frontline family and domestic violence support services is urgently needed to ensure that women and children don't remain at risk. And as always, the community legal sector deserves ample and secure funding. As a former CLC lawyer myself, that sector is crucial to access to justice, and it provides top-quality legal advice and support. CLC lawyers move mountains to assist their clients. They often do so either for free or for a fraction of the price that clients would need to provide in the private sector. I note that the NLAP review is currently underway, which is the review of the 5-year funding agreement between the states and federal government for community legal centres, and I urge that it must deliver appropriate financial recognition to this vital sector. I extend my deep gratitude to all of the advocates, practitioners and frontline service providers who continue to fight for better protections for vulnerable people and a safer family law system. This is critical work, but it's not easy work, and we thank you for all that you do. The improvements to the family law system in the upcoming bills are important ones, but there is much more work to be done.
Authorised by L. Waters, Australian Greens, Canberra.